Continuing from the previous discussion on the Real Estate Commissioner's authority related to public reports, it is vital to understand exactly when a public report is required in Arizona real estate transactions. The Commissioner's oversight ensures that developers and subdividers adhere to disclosure obligations that protect buyers from fraud, misinformation, or incomplete representations about property. These requirements are codified primarily under ARS, paragraph 32-2181 through paragraph 32-2183 and paragraph 2184, which outline when a public report must be issued, what it must contain, and which exceptions may apply. A public report is required anytime a developer, subdivider, or agent offers subdivided land for sale or lease in Arizona. The term subdivided land has a precise legal definition. It refers to land divided into 6 or more lots, parcels, or fractional interests, each of which is less than 36 acres in size. The moment a developer begins marketing such lots to the public, whether through advertising, online listings, or direct sales, they must obtain an approved public report from the Arizona Department of Real Estate, ADRE, before entering into any binding contract or accepting earnest money. This requirement applies regardless of whether the lots are improved, developed with homes, utilities, or infrastructure, or unimproved, raw land without improvements. The purpose is to ensure that potential buyers receive full disclosure of all material facts, such as title conditions, access rights, availability of utilities, flood hazards, and any restrictions on the use or development of the property. These disclosures must be made before a buyer signs a contract or pays any funds, allowing them to make an informed decision about the purchase. For example, if a developer in Pinal County divides a 100-acre parcel into 20 residential lots and begins marketing them online without an approved public report, they are in violation of ARS, paragraph 32-2181A. Even if the developer believes that only preliminary interest is being generated and no formal sales have occurred, simply offering to sell or lease without a public report constitutes a statutory violation. The Real Estate Commissioner may issue a cease and desist order and impose administrative fines until compliance is achieved. There are several important distinctions between subdivided land and unsubdivided land, as each category has separate public report requirements under Arizona law. Unsubdivided land is land divided into 6 or more lots, each 36 acres or more, but less than 160 acres. For unsubdivided land, a different type of public report is required, one that focuses on access, water supply, and development feasibility, rather than neighborhood amenities or infrastructure. Both types of public reports serve the same underlying purpose, ensuring that buyers understand exactly what they are purchasing and that developers are held accountable for truthful representations. In practical terms, this means that a developer subdividing a property into multiple residential lots for construction in Maricopa County and a ranch owner dividing a large parcel into several 40-acre ranchettes in Navajo County are both subject to public report requirements, though the details of the report will differ. Arizona law also provides limited exemptions to the public report requirement under ARS, paragraph 32-2802B4. These include the sale of land by one individual who is not engaged in the business of subdividing, meaning a private owner selling off a few parcels from their personal property may be exempt. The sale or lease of land to another developer for the purpose of resale, as long as that developer subsequently complies with the public report requirements before marketing to the public. Certain transfers of property among family members, as these are not considered public commercial transactions. Despite these exemptions, the Commissioner retains discretion to investigate any subdivision activity that appears to evade disclosure obligations. For instance, a developer who attempts to avoid the law by creating multiple single-member LLCs to each sell a few lots from the same property may still be deemed to have subdivided the land. Courts and the ADRE will look to the substance of the transaction rather than its form, ensuring that all true subdividers are subject to the same consumer protection rules. The landmark case, Arizona Department of Real Estate versus American Standard Development Kaiser, just 1979, affirmed this principle. The court held that even when multiple affiliated entities divided and sold land separately, the transactions were part of a single unified subdivision and thus required a public report. The ruling established that attempts to segment or disguise a subdivision to evade ADRE regulation violate both the letter and spirit of Arizona real estate law. Real estate licensees must also recognize their role in ensuring compliance. Agents are prohibited from offering for sale or advertising any property that requires a public report unless that report has been issued and provided to the buyer. Violations can result in disciplinary action, license suspension, or civil penalties under ARS. Paragraph 32, 12185.9. For instance, an agent representing a developer in a new housing community must ensure that every potential buyer receives the ADRE-issued public report before signing a contract or paying a deposit. Review summary. A public report is required whenever subdivided or unsubdivided land is offered for sale or lease in Arizona. The Real Estate Commissioner, through the ADRE, enforces this requirement to ensure consumer protection, transparency, and compliance with state law. The definition of subdivided land includes any property divided into 6 or more parcels under 36 acres. Exemptions exist for non-commercial private sales and interfamily transfers, but the Commissioner can investigate and penalize any attempt to circumvent the requirement. Real estate licensees must verify that buyers receive the public report prior to contract execution to remain compliant with ADRE standards. Discussion prompts. Why does Arizona require public reports for subdivided and unsubdivided land sales? Answer. To ensure full disclosure of material facts and protect buyers from deceptive or incomplete information. What constitutes subdivided land? Under Arizona law? Answer. Land divided into 6 or more parcels, each less than 36 acres. How might a developer improperly attempt to avoid public report requirements? And how can the ADRE respond? Answer. By using multiple affiliated entities to divide property into smaller lots, which the ADRE can treat as a single subdivision requiring a report. Closing remarks. The requirement for public reports underscores Arizona's dedication to transparency and consumer protection in real estate development. These reports ensure that buyers understand the full scope of what they are purchasing, including land access, utility availability, and potential restrictions. For brokers and developers alike, compliance with ADRE's public report laws is not merely a formality. It is a cornerstone of professional integrity, ethical business practice, and legal accountability in Arizona's growing land development market.